Hi. So, I'm back. It's been a while since I last uploaded a video. Pero, as promised, I'll start the political law review playlist. And we will be talking about constitutional law 1, constitutional law 2, administrative law, election law, law of public officers, and law on municipal corporations, and even public international law. So hopefully sa recording na to, I could record up until executive department. Pero hahati-hatiin ko naman siya into separate episodes. Okay, so what is political law? It's a branch of public law which deals with the organizations and operations of the governmental organs of the state and defines the relations of the state with the inhabitants of its territory. So unlike civil law na nag-govern sa private relations ng mga tao, yung political law, yung gino-govern yung relationship is yung relationship ng citizen sa state niya. When you say state, though yung mga tao usually ini-interchange yung paggamit ng term na state sa government, but actually government is just a part of the state. Kasi yung state, it's composed of, yes, the government, but also its people and its territory. Pero more on that later. So let's talk about what constitutional law is first. So constitutional law is a body of rules and maxims in accordance with which the power of sovereignty are habitually exercised. It's a written instrument. In our case, kasi sa ibang states, meron din silang constitution, pero may ibang states na unwritten yung constitution nila. But sa atin, dito sa Philippines, it is written. It's the 1987 Philippine Constitution. And it is enacted by the direct action of the people, in which the fundamental powers of government are established, limited, defined, and by which those powers are distributed among the several departments for their safe and useful exercise for the benefit of the body politic. It is a system of fundamental laws. Bakit fundamental? Kasi, ito yung nagsiset ng ground. Lahat ng mga laws na pinapasa ng Congress, dapat mag-conform sa Constitution dahil yung Constitution, it's enacted by the direct action of the people. Siyempre, hindi naman yung people mismo yung nagsulat. Hindi naman tayo mismo yung nagsulat doon. Pero, yung nagsulat ng Constitution natin, representatives of the people, and yung laman ng Constitution natin, embodies the ideals and the principles of the Filipino nation as a whole. So, yun yung kumbaga basic na law. Yung pinaka-organic na law, yung constitutional law. Ito yung pinaka-supreme na law, na kind of law. So, di ba meron tayong civil law, criminal law, ganyan. Lahat ng yan, mas mababa sa constitution. Pag merong something sa civil law or sa criminal law or sa labor law na hindi compatible or hindi nagko-conform sa constitution, i-declare yun na unconstitutional, meaning wala siyang effect. Kasi, yun yung pinaka handbook natin, kumbaga, yung constitution. So, it must be borne in mind that the Constitution, apart from being an allocation of power, is also a social contract whereby the people have surrendered their sovereign powers to the state for the common good. It's a product of our collective history as a people. So let's talk about the different kinds of constitution. Kasi nga, na-mention ko, diba, na yung mga iba't ibang states or countries. Diba? When I say state, it means like a country. Kasi, yun nga, the state is composed of its people, its government, its territory. So, state yung unit na yan, yung entity na yan. So, yung iba't ibang states, may mga kanya-kanyang constitution. Yung sa Pilipinas, it's written, it's conventional, and it's rigid. So ano ba yung written? Written is one whose precepts are embodied in one document, or set of documents. It is conventional because it is one that is formally struck off a definite time and place following a conscious and deliberate effort taken by a constituent body or ruler. And it is rigid because it is one which can be amended only through a formal and difficult process. So lahat ng yan matututunan natin kung paano yung process of amending the Constitution, etc. later. So ano yung mga other forms or other kinds of constitution? Meron ding unwritten. Of course, yung unwritten, it consists of rules which have not been integrated into a single concrete form but are scattered in various sources such as statutes of a fundamental character or laws, judicial decisions, commentaries of publicists, customs and traditions, and certain common law principles. So yung pinaka-common example nito is yung UK. Yung United Kingdom kasi, common law sila, hindi sila civil law system. Pag sabi mong civil law system, yun may written constitution. Pag common law system, parang meron yung courts nila, yun na yung decision ng courts nila, yun parang nag-govern sa kanila. Yun parang laws nila. Yung sa atin kasi, yung judiciary, yung ginagawa niya, ini-interpret lang niya yung laws na ginagawa ng congressmen natin, senators, and members of the House of Representatives. Tapos ina-elect sila ng people. So in a way, parang yung people yung gumagawa ng batas, 'di ba? So, yung sa atin, written. May mga batas tayong written, may nagsusulat. Tapos yung courts natin, nag-i-interpret lang ng sinulat. Tapos yung constitution, gawa mismo ng tao na nakasulat rin. Ganun sa atin. As to origin naman, again, yung sa atin conventional. So, parang sinadya talaga natin. Meron tayong constitutional convention, pwede rin constitutional assembly. So, parang nung paggawa ng constitution natin, ng 1987 constitution natin, sa time ni late President Cory Aquino, so, yung mga legal luminaries at mga iba't ibang tao from all walks of life, mga best representatives of the people, they came together and they wrote the Constitution as a reflection of the will of the people, of the Filipinos. So, yun. Yung iba naman, evolved yung sa kanila. Hindi siya parang sinadya na gumawa ng constitution. It's more like a result of political evolution. It's not inaugurated at any specific time, but changing by accretion rather than by any systematic method. So again, yung sa atin rigid, may process kung paano i-amend or i-change yung constitution. Sa iba naman, it's flexible. It can be amended by ordinary legislation as in the case of an unwritten constitution. Sorry, I had to take a break. So, you will notice na parang every 10 minutes or so, parang may cut. Kasi nakakapagod din magsalita, no? Kailangan uminom ng tubig and stuff. Anyway, essential parts of a good written constitution. So, it must be, a good written constitution must be a constitution of liberty, constitution of social justice, constitution of sovereignty, and constitution of government. So, constitution of liberty siya kapag merong provision setting forth the fundamental civil and political rights of the citizens and imposing limitations on the powers of the government as a means of securing the enjoyment of those rights. Kaya, yung Bill of Rights, yung mga karapatan ng tao against the government, nasa Constitution din yan, Article 3. It must also be a constitution of social justice. So when we say constitution of social justice, merong mga provisions setting forth economic, social, and cultural rights. A constitution of sovereignty means that there are provisions pointing out the mode or procedure in accordance with which formal changes in the fundamental law may be brought about. It's a constitution of government because in the Constitution, there are series of provisions outlining the organization of the government, enumerating its powers, laying down certain rules relative to its administration, and defining the electorate. So, effectivity of the Constitution. Kailan nag-start mag-take effect yung 1987 Philippine Constitution? So, February 2, 1987. It took effect immediately upon its ratification by a majority of the votes cast in a plebiscite held for the purpose. By that date, the Provisional Constitution or Freedom Constitution has been superseded. So, konting history lang kasi. Actually, marami na tayong naging constitution before the 1987 Constitution. So, kasama dun yung mga Malolos Convention, mga 1973 or 1973 Constitution, mga ganyan. Actually, hindi ko na i-enumerate, pero sa textbooks natin sa constitutional law, nakalagay naman na dyan. Basta, yung mga constitution na yon, hindi naman na siya effective ngayon. Yung present na constitution, yun yung 1987 Philippine Constitution na ni-replace na yung 1973 Constitution ni Marcos. Sa time ni Marcos. So, di ba nagka-people power? Just ignore the cats. So, di ba nagka-people power kasi nga nag-martial law si Marcos. Tapos, si Cory yung naging president. Nung naging president si Cory, nagka-change tayo ng constitution. So, meron actually interregnum na tinatawag kung saan parang wala tayong constitution. So, meron lang tayong parang provisional constitution pero hindi talaga siya constitution. So, nagkaroon ng provisional constitution tapos habang ginagawa nila itong 1987 constitution na to. So, hanggang ngayon hindi pa napapalitan yung 1987 constitution. So, yun pa rin yung nag-govern sa atin. So, functus officio, what does that mean? An officer or agency whose mandate has expired due to either the arrival of an expiry date or an agency having accomplished the purpose for which it was created. So, rules of interpreting the Constitution. So, according to Manila Prince versus GSIS case, the rules are: first, determine whether the provision is self-executing or non-self-executing. So, i-discuss natin later kung ano yung parang pangit ang pagka-pronounce ko, self-executing or non-self-executing. Okay, yun pala. So, i-define natin kung ano yung self-executing or non-self-executing provisions, kung ano yung difference ng dalawa later. Pero, basta yun yung first step. Bibigyan ko na kayo ng idea. Pag self-executing, yung pagkabasa mo ng provision na yun sa Constitution, yun na yun. Pwede mo na siyang gawin. Hindi mo kailangan ng enabling law. As in, yun na yun. Kung anong sinasabi doon, sundin mo na yun. Or pwede mo nang gawin yun. Or write mo na yun kung meron siyang kina-confer na right. Yung iba kasi, na provision sa Constitution, kailangan pang gawan ng batas ng Congress para maging executing. So, yun yung first step. I-determine kung yung provision sufficient na in itself without the need of enabling law or kailangan pa ng enabling law. So, in case of doubt, assume that the provision is self-executing. So, extraneous materials can only be used if the following rules of legal maxims fail. That is, if the plain meaning of the word is not found to be clear, then that's the only time other aids may be resorted to. So, anong ibig sabihin yan? Parang stat ko na to pero basically, kung clear naman siya, just okay na yon. Kung ano yung ordinary meaning niya, ganun na yon. Kasi yung Constitution, ginawa ng tao para sa tao. So, dapat maintindihan siya ng layman. Hindi dapat siya complicated actually. Yung law para sa lahat. As a citizen, duty mo na maintindihan mo yung law. Dapat binabasa mo yung law. Kasi, karapatan mo yun andon yun. Hindi mo kailangan maging law student or maging lawyer para maintindihan yung batas. Yung purpose talaga niya is para sa lahat. Meron nga, 'di ba, ignorance of the law excuses no one. So, hindi mo pwedeng i-reason na hindi mo nabasa yung law or hindi mo alam yung law. The point is, kapag nagawa yan ng proper process, yung law, kapag na-meet na yung publication requirement, which is pinag-usapan natin sa CivRev videos sa kabilang playlist. Kapag okay yan, regular naman lahat, tsaka constitutional naman siya, hindi mo pwedeng sabihin hindi mo alam. So, kung meron kang ginawa in violation of a law, hindi pwedeng excuse na hindi mo alam. So, dapat, as a citizen, alam mo yung batas. So, ordinary meaning siya. Pero pag hindi pa rin talaga maintindihan, like may ambiguity, kasi nangyayari naman talaga yon, then pwedeng humugot sa ibang sources para mas maintindihan. Like for example, sa case ng criminal law, kapag medyo may ambiguity, yung pinaka-primary source para ng courts, kasi trabaho ng courts na interpreting law, is minsan tumitingin sila sa Spanish Penal Code. Yung RPC nila doon. So, ayun. That's the only time if hindi siya clear, if may ambiguity. Self-executing provisions are those which in its nature and extent of the right conferred and the liability imposed are fixed by the Constitution itself. It can be determined by an examination and construction of its terms, and there is no language indicating that the subject is referred to the legislature for action. So, yun nga, hindi na kailangan ng enabling law. Hence, unless it is expressly provided that a legislative act is necessary to enforce a constitutional mandate. The presumption now is that all provisions of the Constitution are self-executing, meaning, again, without need of legislative action for its enforcement. So, hindi na kailangan gumawa ng Republic Act of ganito, ganyan. Yung Constitution, pag tingin mo pa lang, pagbasa mo dyan, self-executing na yan, goods na yan. Hindi na kailangan pa ng law galing sa Congress. Pero kasi merong provisions na parang nagsistate lang ng principle na, or para lang siyang directory, like hindi talaga mandatory, parang suggestion lang ba? May mga ganong provisions kasi sa Constitution na parang nagsasuggest lang siya na gawa ng batas, ganyan. So, ayun, a provision is self-executing if the provision is complete in itself and becomes operative without the aid of supplementary or enabling legislation, or that supplies sufficient rule by means of which the right it grants may be enjoyed or protected. A provision is non-self-executing if it can be implemented only through appropriate laws enacted by the legislature. It is a provision which merely announces a policy, and its language empowers legislature to prescribe the means by which the policy shall be carried into effect. Okay, so verba legis. Very common na legal maxim to. Napag-usapan na rin natin. It just means na whenever possible, the words of the Constitution must be given their ordinary meaning, except where technical terms are employed. Ratio legis est anima. Yan yun na yung pronunciation ko. Where there is ambiguity, the words of the Constitution should be interpreted in accordance with the intent of the framers. Ut magis valeat quam pereat. The Constitution has to be interpreted as a whole. Meaning, kailangan rin i-harmonize yung pag-intindi mo ng isang provision, kailangan in harmony siya sa other provisions. Doctrine of Constitutional Supremacy. So, napag-usapan na rin natin to. It just means that the Constitution is the fundamental and paramount law of the nation. It is a supreme law to which all other laws must conform. Any law or contract which violates any norm of the Constitution, whether promulgated by the legislative, executive, or by private persons for private purposes, is null and void without any force and effect kapag ka unconstitutional ito. So again, dapat lahat nagko-conform sa Constitution. dapat hindi against sa Constitution or contrary sa Constitution. So, essential requisites for judicial review. So, the following are requisites for courts to take cognizance of a legal or justiciable question. Kasi hindi lahat ng bagay, hindi lahat ng problema sa mundo, pwede mong itapon sa court para i-decide nila yung matter, hindi. So, dapat there is an actual case or controversy calling for the exercise of judicial power. Second, the person challenging the act must have standing or legal standing or locus standi, must have standing to challenge. He must have a personal and substantial interest in the case such as that he has sustained or will sustain, pwedeng future, pwedeng para ma-prevent yung direct injury as a result of its enforcement or of an enforcement of a law. The question of constitutionality must be raised at the earliest possible opportunity, and the issue of constitutionality must be the very lis mota of the case. So ito yung judicial review in terms of constitutional ba or hindi yung isang action, yung isang batas. Again, dapat lahat nagko-conform sa Constitution. Actually, hindi lang laws yung dapat mag-conform sa Constitution, dapat pati rin yung mga actions natin, yung mga transactions that we enter into, or kahit yung mga actions ng public officers, especially yung mga actions ng public officers. So, pwedeng may gawin yung presidente, tapos ma-declare siyang unconstitutional, so wala siyang bisa. Pwede rin may gawing batas yung Congress, tapos unconstitutional siya, so wala rin siyang bisa. Ang daming ordinance sa mga syudad na sinusunod na ng mga tao, pero may nagreklamo na nag-question ng constitutionality, tapos na-declare ng court na unconstitutional nga yung ordinance. Meaning, mali yung ordinance. Dapat walang effect. So, hindi porket ordinance yan, yes, susundin mo yung ordinance kasi valid siya until ma-declare na unconstitutional. Pero, again, kaya dapat tayong citizens, alam din natin yung batas kasi hindi pwedeng sunod lang tayo ng sunod kasi baka minsan nagkakamali din yung authorities natin. Minsan, they commit acts that are unconstitutional. So, pag alam natin yung batas, alam natin yung karapatan natin, and feeling natin na unconstitutional yung ginagawa ng authorities, tapos parang may basis naman tayo, yung basis natin, of course, is yung provisions ng Constitution, so pwede nating i-ano yun sa court. Parang i-check nila kung constitutional nga or hindi. I-review nila. Judicial review. So, yun yung requisites para i-take ng court yung ano mo, yung concern mo, whether or not a certain action of the state or its agents constitutional or hindi. So, political question naman are questions of policy referring to those questions which under the Constitution are to be decided by the people in their sovereign capacity or in regard to which full discretionary authority has been delegated to the legislature or executive branches of the government. So, ito yung mga hindi masasagot ng korte. Kasi yung courts, nag-interpret lang sila ng law, sasabihin lang nila yun if they decide a case, whether yung action ba na yan, nagko-conform sa Constitution or hindi. Yun lang naman. Pero may mga bagay na political question, matter of policy, na dapat ilobby mo sa Congress para gawa ng batas, yung mga ganon. So, truly political questions are beyond judicial review. The reason being is the respect for for the doctrine of separation of powers. Okay. So, now let's go to amendatory provisions. So, amendment. What is an amendment? Broadly refers to a change that adds, reduces, or deletes without altering the basic principles involved. It implies addition or change within the lines of the original instrument as will affect an improvement or out wait lang, better carry out the purpose for which it was framed. It is, ang dami kong mali sa notes ko. It is a change that adds, reduces, or deletes. Again, pwedeng dagdagan niya, pwedeng bawasan niya, pwedeng tanggalin niya. Pero kapag ginagawa yung pag-alis, pagdagdag, pagtanggal, dapat hindi na-alter yung basic principle ng Constitution. So kapag ganung uri lang ng change, it's just an amendment. So the guiding original intention of an amendment is to improve specific parts or to add new provisions deemed necessary to meet new conditions or to suppress specific portions that may have become obsolete or are judged to be dangerous. So kasi, 'di ba, yung constitution natin ngayon, 1987 pa siya naging effective. Ibig sabihin ginawa pa siya prior 1987. So 2023 na ngayon. Times have changed. So, sometimes, kailangan na rin ng laws mag-adjust. Kasi yung law na yan, ginawa yan considering the society, considering the times, 'di ba? Para ma-meet yung needs ng mga tao, and yung mga needs ng tao nag-iiba-iba. So, sometimes, it's necessary to change something. Kaya, although na rigid yung constitution natin, pero hindi totally bawal na mag-amend. Pwedeng mag-amend pa rin, pero rigid lang siya kasi may process na kailangang sundin para i-amend. Hindi ganon kadali. Revision naman, also, change rin tong revision. Yung usual na question sa bar or sa law school is, ano yung difference ng amendment sa revision? Yung revision naman, change rin siya, pero unlike amendment, na hindi nag-alter ng basic principles ng Constitution, revision implies a change that alters a basic principle in the Constitution. If the change alters the substantial entirety of the Constitution, as when the change affects substantial provisions of the Constitution, revision yan, yung tawag dyan. Bakit kailangan i-distinguish yung amendment at revision? Kasi magkaiba yung process na kailangan gawin if amendment lang or if revision talaga. The guiding original intention and plan contemplates a re-examination of the entire document if it's a revision, or provisions of the document which have overall implications for the entire document to determine how and to what extent they should be altered. So naalala nyo sa time ni Duterte, gusto niyang gawing parliamentary daw hindi parliamentary, federal. Gusto niyang gawin daw federal yung government ng Philippines. Kaso, nasa constitution na unitary yung government natin. So, pag ginawa mong federal, para siyang United States na style, hindi LGUs, hindi mga cities, provinces, municipalities, hindi ganon, hindi region, magiging parang states. Parang ganon yung gusto niyang gawin, 'di ba? So, that's a revision kasi change mo yung structure ng government. And dahil change mo yung structure ng government, hindi lang yung structure yung maapektuhan. Lahat, 'di ba? Like, paano na yan? Kasi yung batas natin, yung constitution natin, the way siya dinesign is para sa isang unitary, centralized government. So, pag iibahin mo yung structure, maraming provisions maapektuhan, magbabago lahat. Or kung hindi man lahat, maraming magbabago, maraming maiiba. Hindi pwedeng isalpak mo lang dyan na federal, tas same pa rin yung iba, kasi hindi mag-work yun. So, revision yung tawag doon. Pero pag yung change, minor lang naman, or kahit hindi minor, pero parang hindi naman kailangan ng overhaul talaga ng structure ng government natin. For example, walang maraming maapektuhang rights, hindi maapektuhan yung mga ibang batas, then it's just an amendment. So, kumbaga, mas maliit yung amendment, mas bongga, mas malaki yung revision. So, what are the tests in determining if amendment or revision? So according to the Lambino case, there are two kinds of tests. Merong qualitative test and quantitative test. So pag qualitative, inquires into the qualitative effects of the proposed change in the Constitution. So yung pinakatanong mo dyan is, gaano kalaki yung change? How far-reaching is it sa nature of our basic governmental plan as to amount a revision? Yung quantitative naman is, gaano kadaming batas, gaano kadaming provisions sa constitution natin yung mag-change dahil sa pag-change mo ng isang bagay. Yung mag-change rin sila dahil change mo yung isa. Parang domino effect pa. Or kailangan mong baguhin yung iba or mapapawalang bisa yung iba dahil may nilagay kang ganyan. So, gaano kadami yung provisions na maaapektuhan. Yun yung quantitative test. Revision generally affects several provisions of the Constitution, while yung amendment generally affects that specific provision na binabago niya. So now let's talk about constituent power. So yung constituent power is exercised when the Congress is acting as a Constituent Assembly, a Constitutional Convention, or Constitutional Commission. It may also be exercised by the people through initiative. It is the power to formulate a constitution or to propose amendments to or revisions of the Constitution and to ratify such proposals through initiative and referendum and ultimately by sovereign electorate. The exercise of this power does not need the approval of the President of the Philippines or the Chief Executive. So ito na yung klaseng power para gumawa ng Constitution at baguhin yung Constitution. The people can only directly propose amendments to the Constitution within 5 years from the ratification of the 1987 Constitution, which is 1987, 88, 89, 90, 91, 92. So within those 5 years, yun lang yung tao pwedeng mag-exercise ng initiative. Tapos, di ba tapos na yung 1992? Every 5 years, once every 5 years thereafter. So, within 1993, 94, 95, 96, 97, isang beses lang dapat. So, pag may na-file within that 5-year period, kailangan na naman maghintay na mag-1998. So, 98, 99, 2000, 2001, 2002. Dapat isa lang within that period. Tapos, pag naka-file na ng isa dyan, 2002, so 2003, 4, 5, 6, 7 na naman. So, once every 5 years lang. Bakit? Kasi ang hirap din na pabago-bago and magastos rin magpa-plebiscite din sa mga tao. Hindi magkakaroon ng stability. Yung constitution kasi dapat stable yan. Kasi ang daming nakadependeng ibang batas dyan. Mag-change talaga yung government natin, mag-change yung way of life natin kung babaguhin yung constitution. So, hindi pwedeng pabago-bago lang yan. Kailangan may limit. Kailangan hindi abusuhin. For there to be a valid initiative to propose amendments to the Constitution, there must be first an implementing law acceded by 12% of the total of all registered voters. So, lahat ng registered voters, 12% nun. Pero aside sa 12% nun, dapat at least 3% of the registered voters in every legislative district. The people must author and sign the entire proposal, hindi part by part, dapat buo. And no agent or representative can sign on their behalf. And as an initiative upon a petition, the proposal must be embodied in such petition or attached to the petition with proper reference. So as you can see, ang hirap i-change pero pwedeng i-change. Congress can convert itself into a constitutional assembly pursuant to Article 15 of the Constitution, which allows the Congress to have full and plenary authority to propose constitutional amendments or to call a convention for that purpose. However, the Congress can only call for a constitutional convention, but they cannot convert themselves into such. The Constitutional Convention may be called through the following modes: by 2/3 of all the members of Congress, again, all members of Congress, or by a majority vote of all members submitting to the electorate, us the people, the question of calling a constitutional convention. So discuss natin yung steps on how to amend or revise. Steps in the amendment or revision of the Constitution when Congress is a Constituent Assembly. So una, meron dapat proposal for amendment or revision. Proposal muna kung anong gustong baguhin. Made by Congress acting as a Constituent Assembly rather. Ito yung sinasabi nilang CONAS. Congress will vote on it, whether voting separately or not, at its choice. So, paano yung voting separately or not? Kasi diba yung Congress natin, 2 houses yan. House of Representatives, yun yung mga congressmen natin, whether party list or district representatives. At saka yung Senate, composed of the 24 senators. So, magvo-vote sila. If favorable, Congress will then enact the necessary implementing legislation. Then Congress, acting as a Constituent Assembly, shall submit the proposed changes to the people. All amendments must be submitted for ratification at one plebiscite only. So, pagbobotohan ng mga tao, kung okay sila sa change or not, yes or no. After submission, the proposed changes shall be valid when ratified by the majority of the votes cast by the people in a plebiscite held not earlier than 60 days and not later than 90 days, so 60 to 90 days, after the approval by Congress acting as a Constituent Assembly. So, yun yung process kapag merong change, tapos yung Congress nag-act as CONAS. Steps in the amendment or revision of the Constitution when Congress is acting as a Constitutional Convention or CONCON. Proposal for amendment or revision is made by Congress, again, acting as a Constitutional Convention this time, called for such purpose by 2/3 vote of all the members of Congress. Pag sinabi mong all members of Congress, congressmen and senators alike, or by submitting the question to the electorate of whether or not to call a constitutional convention upon a majority vote of all its members of Congress. Then Congress, acting as a constitutional convention, shall submit the proposed changes to the people. All amendments must be submitted for ratification at one plebiscite only. So same lang sa pag-CONAS. After submission, the proposed changes shall be valid when ratified by majority of the votes cast by the people in a plebiscite held not earlier than 60 days and not later than 90 days after the approval of Congress acting as a Constituent Convention. So next way naman, kung hindi CONAS, kung hindi CONCON, People's Initiative or Direct Initiative. So, proposal for amendment or revision is made directly by proposal of the people upon a petition of at least 12% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters therein. So, hindi pwedeng kunin mo lang yung 12% ng total ng lahat ng voters, tapos pag ma-meet mo yon, okay na. Kailangan lahat ng legislative district represented. Meaning, kung makuha mo man yung 12% or sumobra ka pa sa 12%, pero merong legislative district na hindi naka-reach ng at least 3%, wala. People must author and personally sign the entire proposal, embodied in a petition, and only amendments may be proposed, not revisions. So, kapag CONCON or CONAS, pwede revision. Pero pag direct initiative ng tao, kailangan bawal revision, amendment lang. No amendment in this manner shall be authorized within 5 years, okay, yun na naman, following the ratification of 1987, inulit lang natin, nor oftener than once every 5 years. It is Congress that provides for the implementation of the exercise of this right of people. So, currently, we have the Initiative and Referendum Act or RA number 6735, however, it was ruled to be incomplete and inadequate. Pero may ibang provisions na okay naman, pero kulang siya and inadequate. So after submission, the proposed changes shall be valid when ratified by the majority of the votes cast by the people in a plebiscite held not earlier than 60 days and not later than 90 days. Pero yung difference is that there is certification by the COMELEC. Ito yung kinaiba ng CONCON sa CONAS. May COMELEC kapag initiative of the sufficiency of the petition by the people. Okay, so last few topics. Let's discuss judicial review of proposals. So, yung substance ng proposal, it's not subject to judicial review kasi political question yan eh. Pero yung subject sa judicial review is yung manner. Kasi may pinaprescribe na way, diba? So, yung i-check ng court is kung sumusunod ba sa procedure. So, legislative power is the power to pass, repeal, or amend ordinary laws or statutes. It is an ordinary power of Congress and of the people through initiative and referendum. The exercise of this power ordinarily needs the approval of the President unless when it is done directly by the people through initiative and referendum. Kasi the President has no legislative power to propose amendments but can only suggest changes. This is usually done kapag nagsusona siya. Pero, discuss natin later. Pero, ganito kasi yan. Meron tayong 3 branches of government para may checks and balance. Pero, it's another discussion kasi extensive din yung discussion na yan. Pero, ito yung pinaka-basic, yung gobyerno natin. Meron tayong executive department, legislative department, judicial department. Yung tatlong yan. Yung pinaka-visible dyan yung president. Actually, yun yung iniisip natin na parang siya yung pinaka-superior. Hindi. Equal yan. Co-equal yung tatlong yan. Yung executive, hindi siya lamang sa legislative, hindi siya lamang sa judiciary. Ibig sabihin, in terms of like power, and in terms of importance, in terms of superiority, hindi lamang si President kay Chief Justice. Si Chief Justice siya yung head ng judiciary, at kay Senate President and Speaker of the House. Si Senate President siya yung head ng Senate, si Speaker of the House siya yung head ng Congress. Kaso bakit sobrang visible ni President? It's because isa lang siya doon sa executive. Sa legislative kasi madami sila eh. Buong Congress sa body. Sa judiciary naman, buong Supreme Court. Ganon. Pero, co-equal yung tatlong yan. Yung tatlong branches na yan. Kaya si President, yung trabaho niya, executive, i-implement yung batas. Yung gumagawa ng batas, si Congress, yung legislative. So, bawal baguhin ni President yung Constitution kasi wala siyang legislative power. Yung legislative power nasa Congress na galing sa tao na bumoto sa kanila. So, in a way, parang yung tao yung gumagawa ng batas, si President yung nag-i-implement. Yung si Judiciary, yung ginagawa niya, ini-interpret niya yung batas at make sure niya na si President at yung Congress is sumusunod sa batas. So, yun. The power to create the committee rests from the take-care power of the President, hinged from Section 17 of Article 7 of the Constitution, which is the power to ensure that laws are faithfully executed. So again, execution yung concern niya. Giving him the authority to create a fact-finding committee or ad hoc committee in order to study the implementation of the law and the Constitution. As long as the work of such committees is only recommendatory, it is not binding on Congress kasi si Congress pa rin yung may power. The Congress is free to adopt or reject the proposal of such bodies of the President. So, you see, parang nagbe-blend yung powers nila tapos may kanya-kanya silang ginagawa, kanya-kanya silang duty. Hindi puro President lang yan lahat. Kasi kung may President ka lang sa form of government natin na walang ibang branches, wala siyang law na mai-implement. Kung legislative lang, walang mag-i-implement ng law niya. Kung walang judiciary, walang mag-check sa dalawa kung tama yung ginagawa nila. Ganon. So, doctrine of necessary implication, it is the legal basis for allowing Congress to provide implementing rules. The doctrine states that the grant of an express power carries with it, by necessary implication, all other necessary powers in order to implement the express power. Okay, so natutuyo na yung laway ko. Pero, yun na for episode 1 of Polyreview. general lang siya, general provisions. So, sa next episode, which is itutuloy ko lang naman, pero i-upload ko lang separately, we will talk about the state. Okay, so see you on the next one.